I would like to call this meeting of the Board on Electric Generation Siting and the Environment to order. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the Board. To my far right, Lou Alexander, alternate of Basil Sagos, Department of Environmental Conservation. To my immediate right, Dr. Elizabeth Lewis Michael, alternate of Dr. Howard Zucker, Department of Health, New York. Vincent Ravashir, alternate for Eric Gertler, Acting Commissioner, New York State Department of Economic Development, and President and Chief Executive Officer Designate of Empire State Development. And also John Williams, alternate of Richard Kaufman, New York State Energy Research and Development Authority. Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda.
Thank you. With that, we'll get to business. Our agenda today consists of case 14F0490, application of Cassadaga Wind, LLC, for a certificate of environmental compatibility and public need pursuant to Article 10 to construct a wind energy project presented by Ashley Moreno, Chief Administrative Law Judge, Department of Public Service. James McClymans, Chief Administrative Law Judge, Department of Environmental Conservation, is also available to answer questions. Judge Moreno, please begin.
Thank you. Good morning, Chairman Rhodes and Siting Board members. As you mentioned, I'm Ashley Moreno. I'm presenting today on behalf of my colleague, Dakin Lee Cakes, who is presiding over another Article 10 matter at this moment. And as you mentioned, with me is James McClymans, who presided with Judge Lee Cakes and is also available for questions. On January 17, 2018, the Siting Board adopted a recommended decision of the hearing examiners as modified and granted to Cassadaga Wind, LLC, the first certificate under the new Public Service Law, Article 10. Siting Board's certificate incorporated a number of conditions applicable to the construction, operation, and potential decommissioning of the Cassadaga Wind project. Since the Siting Board's order, the certificate holder has been working to finalize its construction plans and has submitted several compliance filings. During the pre-construction process, Cassadaga Wind submitted requests to amend some of the certificate conditions. We are here today to consider two such amendment requests made in petitions filed on August 21st, 2019 and on September 4th, 2019. The August 21st petition requests approval for the relocation of the interconnection point from which electricity produced by the wind project would be delivered into the electric grid at facilities owned by National Mohawk Power Corporation doing business as National Grid. The September 4th petition requests approval for the relocation of 4 segments of access roads, 2 portions of a buried collection line, and a segment of Cassadaga Wind's transmission line. Cassadaga Wind explained that the relocations were necessary to reduce wetland impacts, to reduce grading impacts, reduce the length of collection line, and increase spacing between existing gas wells and the transmission line. On October 7, 2019, the Secretary informed Cassadaga Wind that because the amendment request involved moving some project components more than 500 feet from their certified location, the changes were deemed to be revisions under the Board's regulations. As revisions, the petitions were subject to the hearing requirements for applications. On October 8, 2019, the Secretary issued a notice for an October 30th procedural and issues conference and announced the potential for an evidentiary hearing if the judges determined, based on issues identified at the conference, that the hearing should proceed. On October 30th, the judges held a conference with the parties at which only the concerned citizens for the Cassadaga Wind project raised issues for hearing. The judges opened the hearing and took testimony, allowed for cross-examination, and asked questions of their own to gather more information. After the hearing, the judges left the hearing record open to allow for concerned citizens and the parties to review information provided at the hearing. With regard to the relocation of the interconnection point, at the hearing, National Grid had explained that after reviewing the Siting Board's January 2018 order and working with Cassadaga Wind, that Niagara Mohawk determined that a relocation of the interconnection point was necessary. In addition, the statutory parties noted on the record that they had reviewed the petitions and did not find any issues in need of adjudication, although DPS and DEC did raise some collateral issues that the parties were able to resolve on their own. Those resolutions have also been incorporated into the judge's recommended decision. Concerned citizens had raised some issues about the potential impacts on wetlands and proposed mitigation, about the potential for noise from the interconnection move and from construction equipment for other relocated project components, about the process followed by the developer with the State Historic Preservation Office, and general concern with the certificate revision process that allows for revisions to be sought individually rather than requiring all revisions to be sought as one comprehensive filing. However, on November 13th, concerned citizens informed the judges that it was withdrawing the noise concern that the judges had left open. That was the one issue remaining. The judges determined that no further process was necessary and produced a recommended decision. The Secretary issued that recommended decision on November 26th, noting that she had determined that it could be presented directly to the board without requiring exceptions, and issued a notice of today's meeting. My apologies. Having reviewed the record, the judges recommend that the Siting Board find that the relocations are necessary and desirable, and that the impacts have been minimized to the maximum extent practicable, that the project modifications will comply with the applicable state freshwater wetlands protection laws, and that the issues raised by concerned citizens have either been adequately addressed or are not in consideration in the limited scope of the review of these petitions. So today you have before you a draft order that would adopt the examiner's recommended decision to grant those two petitions. This concludes my presentation, and we are available for any questions you might have.
Thank you. I'm convinced that these are good revisions that make sense for the project, in fact, are necessary and beneficial, and that do a good deal to even further reduce impact. So on the substance, I'm in favor of this item. On process as well, I think this has been good process. Properly submitted, opened up for comment, effectively addressing the concerns that were raised, and generally fully meeting my own standards and the standards I believe in the regulations of good order. So I'm going to support this item. Thank you very much. I now turn to my colleagues. Are there any questions or comments from my fellow board members?
I just have one question. Relative to the revisions to the certificate conditions that are part of the attachment, I just wanted to ask, with respect to the revision of Clause 131, it's my understanding that we're applying appropriate construction work hours to the town of Stockton facilities as well.
Yes.
That's correct. DPS staff had proposed all of these revisions, most of them related to the actual modification petition that's before the Siting Board now. This one, Clause 131, however, was to correct an oversight in the original certificate. The working hours provided for by the town of Stockton's local law had not been included in the original order, and so DPS staff recommended taking this opportunity to correct the certificate and include those hours.
All right, thank you.
Mm-hmm.
I have no questions.
Vince or John, do you have any questions, comments?
Maybe muted?
Are you on mute?
Just, yeah, I could hear that.
You could hear that?
No, just put phones down.
We need them to be able to speak, don't we?
We can't hear them.
Is the phone
Are you able to unmute in New York City? We cannot hear you. Can we?
Yeah, are you doing the unmute button?
Can you try again?
Can you speak? Can you hear us? Okay, can you talk so we can hear you?
They're speaking. I can't hear.
Okay.
Yes, please.
Let's go off the record.
I don't think that works. Can we put them on, can we phone them in?
No, we're calling Jan to see if he can come and assist in the room.
That's right.
Can you try again, please? Just speaking?
Yeah, can you hear us now?
Oh,
Yes.
thank you.
Okay. Back on the record.
Do you raise the volume, though? Or how do we raise the volume? Can you speak louder? Can you speak again?
Yes, can you hear us now?
Thank you. Back on the record. John Vince, do you have any comments or questions?
I have no questions, and I have no questions.
Thank you very much. We'll now proceed to vote on the recommendation. My own vote is in favor of adopting the examiner's recommended decision, thereby approving the requested revisions to Casadega's certificate as described. Mr. Alexander, how do you vote?
I vote in favor.
Dr. Lewis Michael, how do you vote?
In favor.
Mr. Ravashir, how do you vote?
In favor.
Mr. Williams, how do you vote?
In favor.
The matter is approved and the recommendation is adopted. Secretary Phillips, is there anything further to come before us today?
No, there is not.
Thank you. Thank you all. With that, we are adjourned. Thank you.